Good evening, members. Welcome to the statistical meeting on the Digital Personal Data Protection Act 2023. We have eminent speaker CA Nrasimhan Elangovan. I welcome to the session. It's my pleasure to introduce the speaker, CA Nrasimhan Elangovan, BCom, FCA, CS, DISA, DIPA-FR, CISA, and Certified Data Privacy Solutions Engineer. Senior Advisors, Digital Security Services in Crown Advisory Services India LLP, Honorary Program Director, ISACA Bangalore Chapter. CA Nrasimhan Elangovan, a futurist cybersecurity auditor and a keynote speaker. His areas of practice include cybersecurity audits, SOC 2, ITGEC attestations, auditing emerging technologies such as AI, big data, IoT. He is a faculty for DISA and CISA and courses on blockchain technologies. He has authored more than 7 books for ICAI, KSCAA, etc. on technology. He is a regular speaker on technology at various national and international conferences of ICAI, ISACA, CIA, ICCI, etc. He is often addressed ISACA international conferences at Asia, CACS, Europe CACS, Africa CACS, North America CACS, and often amongst the top rated and youngest speaker. He has been identified as one of the top 10 influential consulting leaders 2020 and annual recognition for torchbearers in the consulting spheres by CEO Insights magazine. With this brief introduction, I welcome to the session, sir, and I'll leave the session.
Good evening. So nice to meet all of you, and very interesting topic. For the first time in a country like India, a legislation to protect data and to govern data privacy is coming. It's one of its kind. And the moment we say one of its kind, it obviously means one of its kind, new opportunities. Of course, one side is new problems. What do I do in my office? I have to make sure I comply with it. I have to make sure my clients comply with it, right? But I see the positive side of it where this can be definitely looked as an opportunities. Before I get started, let me also give you a perspective. Of course, it will cover through during the session. Why privacy is such an important thing now? I'll give you a few scenarios. Recently, we as chartered accountants have received so many calls from banks saying we will provide you unsecured loans or professional loan. And that too, it's an auto voice record message. Have all of us come across this? Now how did we get the data? Nobody knows. And the beauty is, it will say once Bajaj, one more say it will say IDBI, one more say it will say Axis Bank. You go to these banks and raise a complaint, they will say that, sir, we are not the person who are doing it. It's very difficult for you to establish. And they call you from a number which looks like a genuine mobile number. See, when we are into profession, one side we do not know who is a new prospect who will call us. Because we obviously need to get that. See, at the end of the day, when we are into profession, we are our own business development manager, we are our own salesman, we are our own execution. It's another matter, we play different roles. Right? And of course we may have other people to help us out. Now, if you just take this one scenario, I know a particular time at which this call comes. So that time I don't answer any calls which comes in. Right? It has become to that extent. And we are left without an option. Now this is where this legislature comes very interestingly. It talks about how one should govern the data which is personal in nature and digitally available. 3 things. It should be data, it should be related to a person, it should be digitally available, which means I am giving a physical visiting card. DPDP is not applicable. Why? Look at the very wording. Digital personal data. I'm just giving you a perspective, right? Second, for the first time, a legislation has come up which is just 30 pages. 30 pages, right? I can probably...
21 pages.
Okay, 31 pages. Sorry,
21.
21 pages, I beg your pardon. 21 pages, right? Even if you ignore this first few, whatever text is there and last few schedules, I think it's about 18-19 pages of a small piece of law. You might be thinking, sir, for the 20 pages, why do we have to deliberate so much? I'm telling you, this 20 pages is the starting point. Just like your acts have this provision, right? Any other income tax or any of them. You have a base act. And many times the word as may be prescribed is there. So if I just do a word, Control F with word prescribed, I can see 31 times the word prescribed is there. Which is much more than the number of pages itself. Right? And this is just a starting point. Because today, in India, privacy to a large extent is a myth. Why? If you go to a mall and you are filling up a questionnaire and your lucky draw competition, you are filling up something and you are submitting, you will happily do it. But the reality is, with your personal information, what they do, we do not know. Another example, when you go to, let's say, a pizza store or one of these modern new age fast food restaurants, if you want the bill, they will say, sir, mobile number more compulsory. If you ask my mobile number, it will say, sir, for bill generating the bill, because we are giving you digital version of the bill. So with all of this information, I think you are able to understand the role data and digital combined today the game is. Right? So with that in our mind, let us also interpret this regulation. And before I head into little more intricacies, for the first time, a law is using she and not he. If you go to the General Clauses Act, it says he includes she. That's the general interpretation over a point of time. Again, not a gender bias, that's how it has been adopted. But for the first time, the law uses the word she. And here it is slightly giving that sort of a tendency that India is equally looking into this newer aspects and facets which is coming up. That's basically the intention. Okay? So with that as a background, I'll quickly head into the subject. Of course, I think I was introduced, but in short, I am a person who likes technology and I'm a person who likes risk, and I combine both of them in my profession. That's all. Do a lot of technology audits, risk-based audits and assessment. So I thought I'll take you broadly into 4 or 5 domains and 5 themes let us restrict, because the more you go, it is the bigger, the deeper it is. First is of some essence of why this came in, some fundamental concepts. Then definitions, which is very important. The same way you would interpret an income tax or a tax law definition, you could probably interpret it, but I'll give you a different dimension and perspectives based on my experience. Then some key provisions, which is basically the gist of the law. Some insights in terms of use cases, how this can be interpreted, and way forward. So let's see the history. The concept of privacy as a legal subject did not even exist until the courts recognized it. And when did this happen? In 2017. This was one of the landmark judgment of the Supreme Court. Puttaswamy judgment. Puttaswamy versus Union of India. Where the Supreme Court for the first time said, under Article 19, privacy also is one of the fundamental rights. Article 19, I think, talks about liberty and freedom and all of those things. So which means the right to usage of your personal information is a fundamental right. And we all know what is a fundamental right. Anything against that, you can go ahead and file petitions, whatever, with the Supreme Court or the High Court as it is. First. Second, recognizing privacy as a fundamental right, what interestingly happened is a year later, Justice Sri Krishna committee was formed. Now, this gentleman, with lot of his practical experience and interpretation of various things, brought up a beautiful piece of legislation or a book on the recommendations as to if India was to have a personal law. When I say personal law, I'm talking about the data privacy, right? Because personal law could be other personal laws as well, right? So from a data privacy, he came up with a huge set of recommendations, and that is what you see as the third point, the Personal Data Protection Bill came up. Let us also understand at that point in time when the Personal Data Protection Bill came up, globally what happened was, I think about 2 years back, 2016, a very interesting piece of legislation in Europe was passed. And this, in case you have heard when you are traveling or those things, it is called as the GDPR, General Data Privacy Regulation. Simple. In general, what is my data privacy requirements or regulations as far as Europe is concerned? And here in this context, Europe includes even United Kingdom, because this was prior to Brexit. Now that was a law which got more power compared to the 1995 law. Then you will be asking, sir, what is so important in the 2016 law? The important terminology was the penalty. Penalty was 4 times of your global turnover if you do a violation. The moment people heard penalty, it became a serious business. That's all about it, right? And later on you have heard this Facebook issue, Cambridge Analytica cases. All of these under different courts have been, in the European parliaments and European courts have been tested, right? So that's the context if you look into a global perspective. But what happened in India is, they came up a Personal Data Protection Bill 2018, 2019 and 2021. Just like our earlier GST, we had so many versions, right? And then finally it took effect, right? Similarly, the personal data kept on having some changes, alterations. But between 21 and 22, one major change happened. And the word digital was added, which meant that, boss, it is impossible for me to control personal data, therefore I might as well have a legislation to collect only digital. That is one. Second, the abuse in a digital is way higher than an abuse in a personal form, in a physical form. Because today, if I have something, I'll take a simple example, emails. If you provide your email ID, if you go to your own Gmail, majority of you would be having a Gmail ID. If you go to your Gmail, there will be the categorization, primary, then you have what is that, updates, and then you have 100% only called promotion. You would not even have subscribed, sir, but still you will get it. Forget that, you create a new Gmail ID now. Within next 3 days you will get one promotion alert, or you have not even used it for anywhere else. Because that is the very nature in which something happens. How they got the email ID, we will not get into those level of details. Which means, the abuse from a digital perspective is way higher, and the benefits which they can obtain also is way higher. That is why today, unfortunately, a TV ad is sometimes a little cheaper compared to a Google advertisement or a Facebook advertisement. How is Google and Facebook making money, sir? It's all with digital data, with all with advertisement. And how are they making advertisement? Based on the words which you would have searched. A classical example, you wanted for Dasara or for Deepavali, you wanted to buy some ethnic wear, simple thing. You just went online and saw the price. Now there is some season sale also is going on. Now the moment you go search it, is it the end of the story? No. In your Facebook, LinkedIn, Tax Guru website, everywhere this advertisement will follow you. You agree? What are they trying to do? They are trying to take your, based on your search history, they are trying to stake and monetize that. And interestingly is Facebook gets advertisement for display and per click. You need not even buy, but you have clicked. For that they will charge. And that is how Facebook, Instagram, all these fellows have made so much money. And that's the modern business today. Advertisement revenue. Right? In between this, there are so many intermediates. That's a different story. Probably in some other day we'll discuss. Right? When it comes to these newer businesses. That means the abuse and the reach of digital personal data is way higher. You might be asking, sir, does Facebook, who's sitting in US, get to know that I am sitting in Kamakshi Palya or Kalas Palya and I've searched for a shoe? They will get to know that somebody with this IP address has searched for the shoe. They will not know it is Mr. Alexander or Mr. Romeo or Juliet or Mr. Madhav or Mr. Rishikesh, whatever name. I hope you are able to get that. Right? So that is the context we will have to keep in our mind, and that is when in 22 it came up as a digital personal data. So typically, knowing the way in which legislation was maturing, we thought 2018 it didn't pass, 19 it didn't pass, 21 also it didn't pass, so 22 only name your pass, nobody bothered. 23 they introduced once again Digital Data Personal Bill 2023. So we thought, okay, again the same issue. But 2 months back, or rather, a month back, I think 2 months back, because it was in August, right? This was passed in the Lok Sabha, Rajya Sabha. President also gave the autograph, which means it became an act. Only thing what they have done is they have not notified the date from which it is applicable, and of course we will speak about that, right? So with this as a background, so I hope you are getting the context that what we are speaking of and how we should be probably looking into the next one. So if I read the purpose of the act, it is very simple. Processing of digital personal data. The word processing has the widest interpretation. I can discuss one day only on the word processing. So much is that. We will discuss that. Of course, not in a day, but in a slide we will see how much we can discuss on that. So if you are processing digital personal data, that means this act is applicable first. Each of these words will spend a few minutes. And the reason is because of these two. A, the right of the individual to protect their personal data, which means if you are sharing your information to a pizza delivery company or a Swiggy, Instagram, whatever, what is it, Instamart or whatever, you have a right to protect your data. Right? And why are you giving it to Amazon or Swiggy or any of these fellows? Sir, he has to call you, only then he can deliver. That means the intention is, can he deliver the product without your mobile number? Very unlikely. Very unlikely. Maybe he can come over there, you are continuously watching him because you are very hungry for that evening or something, and immediately you go sometimes in the balcony and you are walking and he comes and you deliver. So that's a very peculiar case.
He will not be able to identify that.
You will, again, we do not know who's ordered because so many people are there. If you are an apartment complex, again, so many complications are there. Correct? So, right of an individual to protect the personal data, and very important word is this last three. Use the personal data only for lawful purposes. Right? So, the law itself, by a very fact, the purpose of that, if I would probably call it as the preamble of that, it talks about the concept. And if I take the next thing, as I said, President gave the golden signature on 11th of August. Yet to be notified. The last is a very interesting point, and I would like to remind you to few years back when the Companies Act 2013 was notified. One part of the Companies Act was notified, other parts of the Companies Act were not notified, if you recollect it. It came in installments. And at one point of time we had to interpret 1956 Act as well as 2023 Act. It became a very complicated affair, but we didn't have an option. It was a very short term. Unfortunately here, or rather fortunately, we don't have an equivalent legislation. One very important thing. Many of them say, sir, we don't have a data privacy law in India. I would not agree. We do not have a formalized and a codified law, which is agreeable. Why? Because there is information technology sensitive protection of data rules 2011 to a limited extent that acts like a personal data law in India as of now. Right? So keep that in mind. So are we clear with the context and the preamble and other aspects? Right? So I'll quickly take to the next one. One fundamental concept I want to clarify. Concept of security, privacy, protection. Because very often this is an how do I call it? It is misunderstood or interchangeably people think of. To give an example, what is security is not equal to privacy. I will rather say these are two different faces of a coin. Why? Let's take a very simple example. You have written a small message. You have written a small message and you have kept it on the table. And you are sitting right next to that. so that nobody is actually picking up. Is it secure? The answer is yes. Now you are giving it to Mr. X, and Mr. X is the only intended person to whom that message is supposed to go, and you are physically handing over to him. Is it still secure? Yes. You are giving only to an authorized person. But what Mr. X does is, he takes a photo of that and puts a status message. Or there is some information over that, he calls up some people and starts telling this. That means, first part the data was secure. Second part the data, and let us presume he sent it only for 3 people. He sent it only for 3 people. But the challenge is that these 3 people may not be the person for whom I originally intended to send the message. I hope you are with me. That means security is purely from a safeguard, unauthorized access. Privacy is, are you using for the intended purpose? I'll give you a very crazy example. Let us say a client gives us income details and let us say some basic information for filing the income tax return. What is the purpose? For filling up an income tax form, for advising, calling him for OTP. All these are understood to be a purpose. But you call him up or you give these details to some Mr. XYZ and he starts sending some advertisements, ATC policy, mutual fund policy, all of those fancy stuff. That is a violation of privacy. Are you clear with this? Or you yourself, or through a colleague or a representative, you go ahead and call up them and say, hey boss, take this product and all of this. Right? So in that case, the focus from a privacy angle is different. I hope you are able to understand. That means, today you may have the best safeguards, but you might miss out on privacy. That's what I am trying to say. Right? And protection is probably a combination of both of them. And that's why it's called digital data protection. Are you clear with this? So I hope I have cleared there in terms of concepts. Any questions here? Because we are a smaller audience, we could obviously have questions. And if there is any, I will be happy to address. Okay. Next we will go on to some key definitions. And first and foremost is data, personal data and digital. If you look into it, data, it talks about various things. It talks about representation, information, facts, concepts, opinions. All of these, last 2 words is interesting. By a human being or by a automated means. Now what is the meaning of an automated means, and that is where you need to understand the concept of Web 3.0. It's called a semantic web, we say. In simple language, machines are constantly generating data. What is a machine generating data about you? Very simple. Many of you from your home or your office or from your client place, you came here. At least I am presuming a good 60% of you would have used a Google map to come here. Even though you know the route. Why? You want to know which is the fastest way to go, considering rain, considering water, traffic and other things. That means, does Google get to know there are multiple people who are coming from different locations over here? The answer is yes. If you do this daily, presuming that your residence is somewhere on the side, Google at 5:45 will give you an alert next time that if you want to start here, this is the right time. And it is doing that. Are you with me? That means this is automated data. It is able to understand. That means that is also data. Okay, we have not gone into personal data. We have just understood what is the meaning of data first. Second, the latest buzzword in all in our offices or in the last 1 year, Chat GPT. You inform something to Chat GPT, it gives you some write-up, something it gives you, sir. Useful or not useful, secondary. It is automated data that also falls within the meaning of data. I hope you clear. So image, opinion, view, anything and everything can become a data. A news coverage also is data. Because it's either mentioning facts or it is giving an opinion. Because some of these news programs also have an opinion, verdict and all those fancy stuff. Now let's go to the next step. So that means we are talking about a data. Understand this to be a top of the funnel. Now we are coming one level down. Which of the data is personal? And the wordings they use means any data about an individual who is identifiable by or in relation to such data. That means by reading that I should be able to identify who that person is, or in relationship of 2 or 3 data variables I should be able to identify. This is a beautiful way in which they have articulated, and I like this definition. Let us say you write a message or share a post or something, you say, I met one of the tallest actors in Bollywood. I am telling you, I met one of the tallest actors in Bollywood. What would your answer be? Most likely Amitabh Bachchan. That means you have not revealed the name of the person, but you are revealing certain attributes based on which you are able to identify who that person is. Personal data. Example 2. I met the oldest person in India. Whatever. Or I met a person who is 100 years plus and still practices yoga. I think there was one gentleman who received a Padma Shri, right? Padma Shri or Padma, I think Padma Shri. He received a Padma Award. So I think you'll be able to correlate it, right? Reverse. I met a person via probably Insta, or rather I'll put it this way. I am a garment manufacturer or a shoe manufacturer, and I got to know that somebody in Bangalore within the radius of Vasantanagar at 6 p.m. always requires a travel from there to here. That is also personal data. Right? And this is what is machine generated, and this is what is available as Instagram advertisements or LinkedIn advertisements, Google AdWords, whatever fancy name you call it. And in case you have not tried Google AdWords or Instagram AdWords or anything, just go fill up the form. Don't even try. Don't even go to payment page. Just assuming you are just selling one shoe or some product, just fill up the details. Try. It will say which location do you want to market. What is the radius at which you want to market? Right? And you try this, and I am giving you examples. This is such a dynamic that if you go to a different state, you will get that particular region's real estate advertisements, I am telling you. 100%. If you are in if you are in Bangalore and you are, let's say, getting some Facebook advertisements of some properties, a couple of days later, let us say you go to either Mysore or you go somewhere in Hyderabad. Immediately you will not get it, sir. Maybe in a day or two you will get advertisements over there of Hyderabad, because that is that level of dynamic, right? So I hope I was able to address what is the meaning of a personal data. The important word to note is individual, which means, carefully understand, the word person under the data protection or the DPDP is equivalent to the income tax definition of person. What is it? Individual, HUF, partnership firm, LLP, company, artificial juridical person. All of these people are treated as personal. But the word personal data only speaks of. That means if I am having in my database some company's details, I am having an email ID support@abc.com. It is not a personal data. You are able to understand that? Support@hp.com. It is not a personal data. Giridhar@hp.com. Personal data. Clear? Right? Come to the digital data. It means only such personal data which is in digital form. And a classical example, if you go to a new client place for the first time, I am not talking about a small SME, maybe a reasonably large size client, they will have a receptionist and they will say, sir, please enter in the visitor book. Why so much? You go to some of these GST offices also, they say, sir, please enter in the list. Now you are giving your name, mobile number and other details there. Obviously there is a question, how will he use the data? By the way, there are companies who just come in these places, take photographs of that and go. They want data, no? Right? So now you are giving information, digital, no, physical. So therefore the scope of this law will not apply. Alternatively, the same scenario you are giving in a, what do you call, automated app. You go to a place, you are supposed to fill up some form, you enter the details, right? And it sends you an OTP. Yes, the law will be. Are we clear with this? Few keywords which have spent some good amount of time. Next, 3 very important definitions in the law. First is the word principle. Whosoever personal data you are processing, that person is called as a principal. Simple. Whosoever personal data you are processing, that person is called as a principal. Example, I am a chartered accountant. For the income tax filing purpose, I am taking some details from my client. My client in this example is the principal. In case of Europe and rest of the world, they use that word called data subject. In India, on purpose, they use the word principal because of the next word, which is fiduciary. Whosoever is obtaining the data and deciding the means and purpose of such processing is a fiduciary. To give an example, you are registering for the first time with Swiggy or Instamart, whatever. Your data will always be, you are in this context data principal. Swiggy or Instamart will in this context be fiduciary. The reason, globally this is called as controller. Globally this word is called controller, and globally they use the word data subject. In India, on purpose they use a different wording, fiduciary and principal. Why? Because they wanted to tie up with the law of agency. Agent-principal relationship, a fiduciary, a trusted person, and therefore they said by the very name, if I am giving my personal data to somebody, I need to have that implicit trust into that person by virtue of that name. So therefore they said data fiduciary, data. Are you with me? Next, this principle includes, very interestingly, in case of a child, and the definition of child is 18 years, or who's not reached the age 18 years. That means in case of a child, the principal is not only the child, but also the parent or the legal guardian of the child, which means your child is enrolling for an inter-school college competition where they are asking you some details. Forget that, sir. You are giving your details to school itself. Or for 11th and 12th you are changing, you are giving some details. Presuming the child, because at 11th and 12th standard the child is obviously not 18 years, right? On the first year of degree, second year of degree is normally well done. At that time, if you are giving your details of the child, in addition the parent also will be in that context treated as a data principal. Why? Because a little later we will understand this. There is a concept of consent. And consent of the child may not be relevant, rather consent of the parent will be relevant. Now very interestingly, there could be a scenario. I am signing up for an app like Byju's, what is that, lot of fancy this thing we hear, no? Coding for child, whatever. Good or bad, I am not going to discuss here, so we can that's a different topic. But intention is what? The child is getting enrolled. Even in such case, the parental consent becomes mandatory. We will address that in that particular way. Right? If a person is with a disability, guardian shall come into picture. So, to a limited extent, this is like your Indian Contract Act. Right? There are practical challenges which will come to it later. Fiduciary is a person who decides the means and purpose, or determines the purpose and means of processing data. And then you have a processor. This person is an intermediary who directly does not get the data, but who processes the data on behalf of a controller or a fiduciary. Are you with me? Which means I am collecting my client's data through a Google form. I am collecting my client's data through a Google form. Google in this case is a data processor. I am a fiduciary. Sir, can Google ever become a processor? It will become a processor to the extent of the personal details you are creating with Google for creating a Gmail ID. Facebook will become a fiduciary to the extent of the personal details which you are sharing with Facebook and other things. Are you with me? Yes, ma'am.
Can CA be the data processor in case of filing return?
In case of a filing return, I think a CA would come under fiduciary because he is deciding the means and purpose of processing. Because what data to process or what data you have to collect, we are the person who are deciding. And we are advising the client, so therefore in all means we will become a fiduciary. When a CA will become a processor, I will tell you. You are working with any of these websites like ClearTax, some XYZ websites, where they collect the first-hand information and you don't even know who the client, but you are doing some work and giving back to them. In that case, you will be a processor. Are you clear? And when I say CA, it could be in any tax auditor, consultant, whatever. I hope that is clear. Right? And let's take another example of an insurance company. You are taking an insurance policy for obviously health, whatever it is. So the person who is taking the policy is in simple language, the policy holder I will call as the principal. The fiduciary will obviously be the insurance company. But this insurance company, before it processes your insurance, prior to COVID, directly you are getting insurance. Today, post COVID, they are mandating that one health checkup shall be done, only then they will give you the policy. So while doing the health checkup, if you read the policy, there is a provision where they clearly say, I am hereby giving my consent for ABC insurance company to share with a third party. That third party laboratory is a processor. Right? So if all this protection is there, then what is the challenge? The protection, I will tell you the biggest reason why fiduciary and processor is important. Whatever happens incorrect, processor will be safeguarded or the fiduciary will be held liable. Why? Sir, I gave it to whom? Fiduciary. That means look at the flip side. Today the process will be, or tomorrow the process will be, every time when fiduciary gives his or enters into an agreement with a person called as processor, mandatorily he will have to do a due diligence on the processor. And the due diligence should be in such a way that they will do the checks, balances, do an audit on him. Opportunities. So, as I have not even gone to the slide of opportunities, I am just talking about the concept. So, auditing a fiduciary is an opportunity. Very interestingly, fiduciary is outsourced to a processor, hell lot of opportunities. Because fiduciary wants to get a comfort that the processor is doing in a legitimate basis based on the means, the instructions, all that story coming into it. I'll give you a very jovial example. You wanted to go to Tirupati Tirumala Devasthanam. For Lord Balaji, if you have to take appointment, there is a fee of 300 rupees. Or you can go through the normal route. When you are doing this, they are asking you to submit your Aadhaar card. You go to a website, online fill up the data, Aadhaar card, OTP, some things come into picture, you make a payment. Now in this case, is data protection law applicable to Lord Balaji? You got my question? It will be applicable to Lord Balaji. The answer is yes. As much as Income Tax Act is applicable to Lord Balaji. It is another matter, it may come under donation, exemption, whatever, those things. Right? Artificial juridical person is also a person, and any person processing personal data, DPDP is applicable. In this context, personal data, who is Lord Balaji processing the personal data of you and me? Whoever he is giving appointment, that person. Are you clear with this? So in this context, you can interpret who are these people. Are all of us clear? Of course, when I say Lord Balaji, in this case I am referring to the TDD trust because it's an artificial data. Now, what is the meaning of personal data? This is a very generic slide, and interestingly, examples are not given with reference to personal data in the law. And one interesting piece of legislation, in many laws you will not find this, you will find illustrations inbuilt within the law itself. The law which I was talking of, if I search for the word illustrations, can you notice this? The law itself has illustrations different. And this is how many? It is given about 11 to 12 illustrations. A very interesting piece of legislation, that is why I keep on saying. They have defeated or they have tried to circumvent the normal ways in which a legislation is formed. And as I told, it's a 21-page law. The word prescribed itself is used 31 times. So you can imagine what we can expect in the days to come. Now these are all a few examples of personal data. First name, last name, middle name, email address, home address, phone number, photograph, date of birth, bank account. I think all of us will be able to understand. Credit card number, national ID number, a social security number. In India we do not have a social security number. Aadhaar is not a social security number. Let me clarify that. Aadhaar is only a means to verify a person. Right? Next, tax ID number, which could be probably a PAN card or whatever. Passport, vehicle registration number. I'll give you a very interesting use case how Google was spotted. What happened was, all of you have seen Google Street View? You are going and searching one place today on the Google map. You will find one 360 degree, one small arrow mark like this, something like let's presume 2 semicircles. You click on that, you can actually see the street. Sitting from home, you can see the street which have been recorded maybe 6 months, 1 year back. You zoom in that, you can also, some of these houses you can see maybe a name board, maybe you can see a car. What had happened was, when Google launched the Street View, they went ahead and mentioned this. Without their knowledge, they had already captured the car vehicle numbers. One fellow, what he wanted to do? He wanted to play a game with this. Anyway, Street View had car numbers. So he used to go to Street View, choose the car number, search in some public repository. He used to get all the details, try to reach out to the person for selling a car insurance policy. Google was fine. And that's why today if you see your Street View, all your car numbers will be masked. Try it out. You can search your own house. Of course, if you're in an apartment, it's difficult. Search for some other house, in general. Right? Even the names and other things. Why I'm bringing this is because of this vehicle plate number also is the same. Right? Next, employee ID. You might be saying, sir, I have only employee ID. How is it a personal? Can I identify a person with the help of employee ID? Reasonably, yes. For example, if I say my employee ID is 5595, that's all you know. You have no clue about what it is. I agree, you cannot identify. But please understand, personal data is also read contextually. I have an ID card of some company and then I have this number. Or I say, boss, I work in the tallest building in Bangalore. I have an IT company which is in the topmost floor. You are giving an indication. Right? In that case, personal data, please bear with me. Clear? Next, IP address. Very interesting. Your IP address is a very interesting personal data in a digital world. Because with that only everything works. Sir, what is IP address, sir? Address, in a layman's language, an address for your internet connection. An address for your internet connection. So, if you are sending me a message, or if you are, let us say, listening to this session, or online, tomorrow you look into, or even you do a Google Map search, whatever, you are sending some information, receiving some information. How does the information know that you are the person? Based on your IP address. So IP address has got dynamic variation, all of those things. Let's not go into the complications for now to understand IP address. Cookie ID. What is cookie ID? Let us say you opened Flipkart or Amazon website. Now some sale offer is going on. No? Now after you browsed some details, etc. Now let us say you browsed this one of these websites 2 days back and you are browsing it again today. What will happen is these companies load some of their website information into your browser such that next time when you open the same website, the loading will be faster. And this is called as cookies. This is how internet works. But I can define and design in such a way that that cookie I can keep a track of it. And that is the means through which they get to know that you are the person who was searching for the footwear, you are the person who was searching for a mobile phone. And whenever you browse any other website, this advertisement follows. Cookie. Location data, I think needless to say. Handwriting. Sir, again, handwriting, how will you identify today? Probably handwriting, we have forgotten handwriting only. The only time I think we think of handwriting is a check or whenever you have to do the signature, right? Otherwise, where are you using? Username and password, social media, mobile device, employment history, education history, all of this, right? Again, please bear in mind, read it individually, read it contextually for you to make the interpretation. Are you with me? A few other definitions. Processing, I will take it up a little later, so just be a little patient. Personal data breach, interesting wording. Any unauthorized processing of personal data. I'll give you a very simple example. Every month beginning, you are sending a reminder to all your clients. These are all the due dates, or this is the date on which GST has to be filed. There are two ways in which you can send an email. Take each person's name, copy paste, send. Or you are using one automated software to send it. Or the easiest method, copy all the email IDs, put it into 2CC BCC. If you are putting the person's name into all the email IDs or CC, you are putting all the email IDs, can I say I can get to know to whose all email ID the other person sent? It is a personal data breach. Why? I am using your email ID in an unauthorized manner. How? By me mentioning the email ID in 2 or CC, others are getting to know who is this email ID. And some of the times we will have some clients reply to all also them. Right? It becomes a complicated thing. So, personal data breach, accidental disclosure, acquisition, sharing, use, alteration, destruction, anything impacting confidentiality, integrity, treated as a personal data breach. I think definition of child we already looked into. Processing, I said, I'll come back to. Purpose of processing is nothing but in contract law you have read this word called consensus ad idem, which means without consensus without consideration or any of those things, right? The contract is not said to be valid, with some exceptions. That means both the parties have something binding them. Here, the fiduciary and the data principal. The fiduciary has to give an intimation to the principal, why am I processing your data? That is called a specified purpose. Specified purpose mentioned in the notice given by who? Fiduciary to principal. In simple language, Google is telling me why I am taking your information. Therefore, the word notice is important because this is what is called as privacy notice. Drafting this privacy policy and privacy notice itself could fetch you a lakh of rupees as well, because it's so complicated. So many elements are. And interestingly, they have said what should be the requirement of notice as may be prescribed. So you have to wait for the law to come out. Very interesting word is called consent manager. Again, I will revisit this. And last is significant data fiduciary. Again, in specific context, I will make a mention of it. Only SDF I will mention. We all understood who is a fiduciary, who decides the means and purpose. Now, I can be a fiduciary, you can be a fiduciary, ICA can be a fiduciary, everybody can be a fiduciary. That means, sir, everybody is collecting data. So, if an attack happens on this fellow, an attack happens on this fellow, shall it be interpreted the similar manner? The answer is no. A bigger player may have a larger impact compared to a smaller player. And that is where the word SDF comes into picture. Significant data fiduciary means such class of data fiduciaries which the government will notify based on the following patterns or following parameters. The volume, the risk, impact, the risk and all of those things. in general I would say, whosoever is processing very heavy volume of personal data, I would believe they would come within this ambit of significant data fiduciary. And very important, every significant data fiduciary has to appoint a data protection officer and has to have a data auditor, another professional officer. Sir, what is there, sir? SDF will only be banks and insurance companies. No, sir, wait for the definition. There will be a large chunk of people who will get covered in this. And each and every SDF has to have a data auditor. Who is this data auditor? Again, one more open-ended question. So make yourself updated with all this. I would not be surprised if the institute makes a representation that we have these auditors. Why don't you consider them as data auditors? Let the guidelines come in. Right? In fact, I will be happy to author a book only on how to be a data auditor. Right? Let that come through, right? Because we are talking about in very interesting times. Board, just like a SEBI board, the data protection board, don't want to spend too much time on this. All of us are clear with this? Any questions at this point in time? I know I've taken almost a good 45 minutes just to discuss the definition and this thing, but I hope you found it useful, will be able to connect the dots. Applicability. The first question you will have to ask, I'll probably use a laser pointer here. Is this visible? No. First and foremost, are you processing digital personal data or personal digital data? If the answer is no, forget it. This law is not applicable, don't even go. If the answer is yes, so we go upwards. Are you processing it in India? That means first question is what? You are dealing with digital personal and you are processing in India. Directly applicable, no other questions. So two extremes. Your process, first question is, are you processing digital personal data? If the answer is no, end of the story. If the answer is yes, check whether you are doing it in India. Okay. That means 100% yes. So we thought two scenarios. Now come to the median scenarios. You are processing digital personal data, but it is not processing in India. That means it is processed outside India. Agree? When it is processed outside India, is it for offering or services in relation to something of a data principle in India? And this is where extraterritorial jurisdiction comes into picture. To give an example, Google, hypothetically presume, is not even registered in India. It's not the case, let's presume. Or WhatsApp was not registered in India for a long point in time, until the ministry wrote a mail saying, wrote to the SEM saying, if you don't register, we will ban WhatsApp in India. Right? This happened many years back. They set up a right. So if you are talking about TikTok, that short dance platform, Byte Dance or something like that, no? Some company. That company, whatever that Instagram video, all those fancy stuff, they are assuming they are not even registered in India, but they are processing personal data. Therefore, the DPDP is applicable for them. And this is why I like this extraterritorial jurisdiction. The answer is simple, sir. You are processing the personal data of people who are residing in India. For services you are rendering here in India. It's okay. Now, for example, I am going to Europe and there is a Europe hotel travel agency who is asking my passport details. He is processing my data, but not for services rendered over here, for services rendered in Europe. For that fellow, why should we have an extraterritorial jurisdiction? I hope you are able to get that. But the same hotel group says reward points. I have my another hotel chain over here. My reward points over there you can redeem over here. DPDP is applicable. Are you with me? Interpretation? Right? So I think only the key point you have to remember is the extraterritorial application. I think we spoke about this within the territory of India. Outside the territory, only if processing is in connection of any activity or goods offered to a data principal in India. Right? I gave the example. Non-applicability, interesting. Personal data processed by an individual for any personal or domestic purpose. To give an example, you have a personal driver, not an organization sponsored, a personal driver. Now you are taking the personal driver's driving license, PAN card, Aadhaar card. For domestic personal purpose, exclusion. Clear with this? Next. Personal data that is made available publicly. Classical example, GSTN number. Today I am required to display GSTN number outside what is this, a conspicuous place or something, no? That law uses that word. Meaning, basically it should be available. Now, unfortunately, from GST number I can get to know PAN number. And GST, PAN are all personal data. I think there is no question of doubt. Right? So, what if it is pertaining to organization? Organization or an individual? Going with the presumption that that fourth or fifth character is P. Correct? Fifth, no? Fourth or fifth, whatever, you are best in it, right? So, whatever is that character number. Right? So, even in that case, if it is publicly displayed and from there you got it, to a certain extent, it is not applicable. Right? The key and the most important provision is the grounds of processing. That means, when can I process somebody's personal data? If you ask me, this is the heart. For that, first we should understand, sir, what is the meaning of processing? This circle is the meaning of processing. You are collecting, you are recording, you are just organizing, you are structuring, storing, altering, transmitting, combining, alignment you are doing, transportation, dissemination, restriction, destruction. Look at this word. If you ask me, anything under earth will come under processing. You have just touched personal data. Over. Sir, as an auditor, I wanted to do an audit and I had to know what is the personal data they have, and therefore I asked access. It will come under one of these categories. Are you clear? That means an audit firm is 100% processing personal data. It could be directly or indirectly. Your own clients directly, your clients indirectly. Example, you go to a bank, you are doing concurrent audit, KYC forms you are checking, you have to go inside and see that person's data. You are processing. Only safeguard over there is you are processing, but the data is not coming out of the system into your laptop or your Excel. Therefore, to some extent, safeguard is available for you as well as for them. But does it mean that you are not processing? The answer is no. Right? So restriction, transmission, destruction, organization, etc. But again, you can still go ahead and say, sir, I am only viewing. Right? So I will not go to interpretation of statute, rather I will say, boss, look into this particular chapter. So that means, now we are clear what is the meaning of processing. Anything within this, if processing is applicable, what are we looking at? Grounds of processing. What is the grounds for processing? That means when can I process the data? You can process the data only under two scenarios. Scenario number one, for the purpose for which the data principal has given her consent. Again I use the word her because I told you in the first session itself, her, him, interchangeably used. The law this time has used the word her or she. Right? I'll simply interpret as the purpose for which the data principal has given consent. To whom? To the fiduciary office. Or for legitimate uses. Two scenarios. First scenario, consent. Second scenario, lawful purpose. That means the end of the story, other than what you see in B, without consent, no processing. Are you clear? Without consent, No processing. Now how do I obtain the consent? If a consent has to happen, it is like a marriage. The boy and the girl have to agree. In this case, the data fiduciary will produce the notice. The data principal will accept. In other words, I am showcasing it to you, this is my personal data privacy policy, and you hereby agree for that, and then you are processing. Are you clear with this? So a data fiduciary shall provide a notice in such manner may be prescribed. Very interesting. This is where I said what is the content of notice is still yet to be prescribed. But reasonably we should be able to identify, but the law may come up with more details. And what should the data principal do? Consent. Very interesting. This consent has to be recorded. Which means you need to have a objective evidence tomorrow to show that that person has given you consent. Sir, how sir? No other option. The law says that. Sir, can I presume consent? Silence is not acceptance. Can I presume consent? Right, we'll come to scenarios. All of us are clear with this? I repeat it. First, when do I process the data? Two scenarios. Scenario number one, when the principal has given the consent. To whom? Obviously fiduciary. Second, legitimate purpose. Legitimate purpose, last we'll test. Now come into the main crux. When the principal and the fiduciary produces notice. Principal, we don't use the word accept, we rather use the word gives the consent. Then he can process. Are you clear with this? Very interestingly, the consent is only for the purpose mentioned in processing. Which means, I am subscribing you for mutual fund. I cannot sell services relating to some other. Unless the notice clearly says that boss, I am going to do all of this. Tricky things, tricky times.
But normally that whatever app or mutual fund, they will give a list of
By the time we read that policy only, we will go mad. Do you think today's youngsters will be reading that? We only don't read as law professionals. Ayyo, better sir, consent kodiyadu.
If
Right?
you want to move forward, you have to give consent.
Yes.
If you don't give a consent, how will you move forward?
So, this is where an interesting term is going to come up, or interesting set of things are going to come up. Is it absolutely necessary, or is it necessary for them? So if you look into it, some of these websites, especially California based and US based, they have this. Accept all cookies, accept necessary cookies, decline. If you decline, end of the page. If you accept necessary cookies for your limited purpose alone, you are permitted. If you accept all cookies, then they get much more. So I think this is how it will eventually span out. But it will take some time. In general, in India, what they will do is, I am telling you, and in fact, some of the clients are doing this, because they, at the end of the day, they cannot keep on obtaining consent. There are practical difficulties. And the way in which business is running today, tomorrow I don't know what line of business I am going to introduce. So, they are going to word this definition broadly, but tomorrow it can be challenged in the court of law. Boss, I wanted to simply take one photograph of me, that selfie app, whatever is that. Let us say that app is doing some cleaning, facial, all those things in that app only it is doing. There are some apps which do that, no, before you submit it, right? That bleaching, all those things that app is doing. Why is the location required for that app? Now they could challenge all these claims. Whether court will accept it, whether the court will understand what is the meaning of location, whether court will understand, these are all practical difficulties, sir. I hope I have answered your question. Now, what is the requirement of notice and consent? Right? I am just going into the deeper section of this, because this is the crux. If this you are able to understand reasonably, you have got the gist of it. The consent should be free. Means what? There should not be some sort of a force or something. It should be specific, very important. I hereby give my consent to do everything what is required. Difficult. Difficult. You can say, I hereby give my consent for all the acts necessary for income tax filing. That's okay. Because I cannot keep on defining everything in a income tax filing. Because tomorrow they will say a new procedure is there. Right? Next. It should be informed. That means the other person should be well educated or aware of it. Unconditional. This is like your trust. Irrevocable trust. Revocable trust, all those concepts. So it should be unconditional. Very clear, meaning unambiguous. No ambiguity. I feel like this, you feel like this, no. Clear affirmative action. Very important is this word. Means what, sir? I have to put a tick mark. Some of these websites you will see, by default the tick mark will be there. That is not acceptable. Right? Signify an agreement to process the data. That means there should be an indication that here, boss, I actually am agreeing for it. Now you can imagine how the notice should be drafted. You should factor all of these points. Now the notice should have these additional information. First, details about the personal data that is to be collected. What is the personal data of yours which I will collect? Let's take a CA office itself. What personal data will collect? Income tax login credentials, bank account details, mobile phone, PAN, Aadhaar, driving license. I don't see a relevance. Right? Unless we are processing digital signature for which we require an alternate proof, that's a different scenario. Passport may not be relevant unless he is a non-resident, because you have to calculate the number of days of stay and all those things. So don't blindly think one data is not necessary. Right? So you could articulate it that way and then create your privacy. Sorry, sir? Then KYC maybe it is required, yes. Again I said, income tax filing versus DIN KYC. Now you are a firm which does only income tax filing, or the client might say, sir, my ROC and other things somebody else is doing, only income tax you take care. Purpose limitation. Right? Okay. Next, the purpose for which such data is processed. Income tax processing, GST return, applying refund, whatever. Rights of the data principle should be there. That means what are the rights that that person has against the fiduciary. Right for redressal, right for questioning, right for erasure, all of those. Manner in which a data principal can make a complaint to the board. Should you have any issues, you can complain to so and so. Like in your Air Suvidha app, if you have heard. There is a mechanism where, or even in flights, they make an announcement at the time of landing. In case you have any issues, etc., you want to raise a complaint to someone. Clear? This is another interesting point. The option to access the contents of the notice should be in all possible languages or any language in the 8th schedule. I think about 20-25 languages are there in the 8th schedule. So you could have the different languages also. Right? Let me tell you, this is a very interesting point because lot of Desi and regional content, there is opportunity here. If you see earlier, a phone was available only in English. It was then available in French. Now today almost all languages are available. You can go to the settings and just make them and you will find them. Simple example, sir. You look at the auto cab driver, sir. When you give the OTP, you will find that either Kannada is there, Tamil is there, Telugu is there, depending on which region you are. Right? Correct? Similar notice, interesting. What if I already have the personal data? I already have personal data, I am already processing. In that case, what do? You should give a notice as reasonably practical as so as the law comes into picture. Should they mandatorily give a consent? That is why the law is a little open-ended. Your job is to give a notice. If they are not given a consent, doesn't matter, you can still continue processing unless they do a reversal. They hereby reject it. Boss, don't process my personal data. That's a different story. One more point, remember, this consent obligation, you have to read it along with the data rights, along with sector-specific regulations. For example, now let us say that a client gave you income tax return or company KYC director, some details you collected, you filed. Now you are filed with the ROC. Now the client says, no longer I am going to be your client, I am moving out to a different auditor for various reasons. Okay. Now he says, give me all my data back. delete all my data in your systems. Can you do it? Difficult. Why? We have a code of ethics and a professional standard which requires us to preserve data for 8 years and 10 years as the case may be. So that law will prevail over the data privacy because it's a general purpose, that's a specific law. Likewise, a bank, I performed a transaction, I told the bank delete all my data. Not possible. Why? Prevention of Money Laundering Act. 10 years the records have to be preserved. 10 years. Your Companies Act also says only 8 years. PMLA talks about 10 years. Right? So probably if you have to summarize, this could be a way in which you can interpret. Clear, affirmative, unambiguous. That means individual has to give a clear perspective. Silence, pre-ticked box. Inactivity, that is silence, cannot be considered as consent. Individual must be informed. He should know about controller's identity, purpose of processing, how to withdraw the consent. It should be specific. It cannot be hidden in the privacy policy, or make it explicitly available. Cover all the processing activities. There should be, if there are more than one purpose, then separate consent for each of them. Prohibitions of bundle consent, for everything on blanket consent. So these are all practical challenges. We'll have to see how we do it in the days to come, which we'll have to look at. Clear? Happy to take a couple of questions, if any.
So when we say the data is being processed in India, see we have this server set up of the Amazon or the Google's outside India as well.
Okay.
And we say the region of processing is US. So does this come even then? But the person operating the system would be sitting in India.
The multiple scenarios here. I am using the services of Google or Amazon. Who am I is the first question. I am using the services where I am using it for my own personal purposes, domestic purpose, ignore. I have developed one app like Zerodha, Upstock, or let us say Swiggy, Insta, whatever. I have developed an app whereby I am taking the personal data inside this app, and this app is hosted in America, Singapore, any of these regions. Before even going to this law, I am registered in India. I am processing the data in India. Therefore, this law is applicable for me because I am processing. Is it applicable for Google? Yes. Even if Google is not registered. Why? Because, go back to the extraterritorial jurisdiction. It is done for processing and rendering services in India. Now you could always argue, boss, how will Google get to know what Upstock or what Zerodha is using of a Indian customer? To that extent, Google is safeguarded because Google is only a processor, not a fiduciary, and you are the fiduciary. Are you clear with this? Over and above this, there is another interesting piece of regulation called as data localization or data sovereignty regulations. In Europe, there is a law, the GDPR says, my personal data should not leave the geographical borders of Europe. There were two exceptions, now only one exception. I am not going to cover that. It's standard contractual clauses, agreement between US and Europe. There were some clauses, we'll not talk about that. In India, there is no restriction that the data should be stored only in India. Rather, they say, unless prohibited, you can go ahead and store. Which means tomorrow India will come up with a negative list. These are the countries where personal data you cannot store, therefore we should not store it. The reason why India came up with this legislation, unlike Europe, is the cost of storing data, which means I require data centers in India. India still does not have that much adequate capacity and bandwidth of data centers. And therefore, the way in which the Indian regulation came up, very smart. Whatever is very critical from India's standpoint, only that data should be in India. Example, RBI, insurance, SEBI. All financial data has to be only in India. Did you know that American Express cannot issue its credit cards today? American Express cannot issue a credit card today. Why? Data localization. RBI told a very simple rule, either you get your server in India and store it here, and that's a primary processing, not in secondary processing. I'm doing a lot of these data localization audits, very interesting piece of this thing. I need to figure out where the data is processed. In fact, even the channel through which it is processing also I have to figure out. Which means if my personal data is going to a US server and coming back, I have to report it. To that extent, this data sovereignty or data localization has become a new game. Imagine Russia's data was with its unfortunately friendly neighbor, Ukraine, or vice versa. And it stopped and said, boss, your data is in my server, cut the connection, gone. My entire data gone. That is exactly happened with QuickBooks last year. Overnight, QuickBooks said, boss, we are shutting shop. Where was that data? In US servers. When all of a sudden you shut shop, all my financials reporting, where will go? That is why India brought up a new piece of regulation. Effective August 2022, and this has to be reported in this year's audited financial statements in case you have missed it. Where it says, every company, their financial data should be accessible from India at all times. They did not say the financial data should be in India. Understand the difference. They should be accessible from India at all times, and beautiful wordings. The backup of this data has to be taken daily and it has to be stored only in India. So even if you are not able to access the financial statements, doesn't matter, I have the backup. Sir, once in a year I do backup. Daily backup mandatory. Sir, I am doing accounting for so many companies. Sir, please check whether you are doing backup, sir. If you are not taking backup, it is a non-compliance. Look at the way we are heading into. Not taking a backup, probably you may have to go to qualify your report. Of course, I am just giving a very hypothetical scenario. You may not qualify your report, but you will definitely give us a emphasis of matter or qualified opinion to that extent. Clear, sir? So the law is very simple. From a personal data standpoint, see whether you are covered under the regulated sector. Today in the regulated sector, it's only these three. Banking, I'll call this as banking, finance, insurance, BFSI popularly called, including securities market. Other than this, see whether if you have any sectoral specific regulations. No sectoral specific regulations, you are free to keep your data anywhere. Correct? Clear? I think examples I've already given. Withdrawal of consent is a plain vanilla. The principal has a right to withdraw consent, right? And such withdrawal shall be similar to the ease at which consent was given. Very interesting. I went and clicked the button, therefore I have given consent. Now revoking of consent, he makes me run to 25 different places and then revoke the consent. Violation of it. I'll give you a simple example. This is like Chakraview. Easy to enter. It should also be easy to exit. It doesn't matter whether Abhimanyu heard that story or not. All that matters is I should have a mechanism to exit. Clear? Upon withdrawal of consent, cease and cause the data processor to cease processing. That means you have to stop the data. But this is the most challenging thing if you ask me. Why? The fiduciary will stop processing. The fiduciary has to intimate the processor to stop processing. Sir, how sir? Let's take an example. You are with Uber, you have downloaded the app. You are using the services of Uber for booking taxi, whatever fancy stuff. Okay. Now what you are doing is Uber sending you that SMS or OTP? Uber is sending that SMS through a telecommunication service provider such as Airtel, but not directly. Uber has one third party company. Uber sends a message to this third party company. This third party company has communication with Airtel. Airtel in turn has sending the SMS. Airtel, Jio, BSNL, whatever it is. Right? Now, you have withdrawn the consent to Uber. It is Uber's responsibility that this app also deletes all the information or withdraws the consent. Right? So, interesting set of things. Of course, regulatory requires you to retain it, then you have to retain it. For example, Telecom Regulatory Authority of India requires this SMS data to be retained for 10 years. Or 2 years, I'm sorry, 2 years I think. In that case, you have to retain it for 2 years. Next comes an interesting case. Other than consent, we spoke about some scenarios. Legitimate uses. First, voluntary provided personal data by the principal. The principal itself says, sir, you please take this, you please take this, you please take this. Then you are permitted to process. Because it is voluntarily provided. To a limited extent, this can be a safeguard. In all your agreements, you write that, I voluntarily provide this data. If assuming that is mentioned between the principal and the fiduciary, you can go ahead and process it. Second, data principal has not indicated does not consent. That means he is not explicitly said no. Right? In that case, you can legitimate purpose you can process. By the state or any of the instrumentalities, which could mean for processing your what is that PGMBY or something, no? Pradhan Mantri, that Jyoti Ujjwala scheme, basically the gas subsidies. Government wants to use your bank account Aadhaar number for processing that, yes, go ahead. Right? Next, for matters concerning public interest, pandemic, medical emergency, COVID, airport authorities. Right? Last is a very interesting thing. This is to protect yourself from vicarious liability. In contract law, there is a vicarious liability where somebody else could be held, you could be held liable for somebody else's act. Typical example, employer-employee relationship. Employee does mischief, employer can be held liable. Employee here is also article assistant. So for the vicarious liability, in order to protect yourself, for the purpose of employment or those relating to safeguarding of an employer from loss or a liability. So you are ensuring that you are doing a basic background verification or all of those things on your employee, you are permitted to process. But you are giving it to a background verification agency, it goes beyond this particular principle. So you need to take a consent of your employee or your prospective employee. So you asked me this last provision, some bit of flexibility for employer-employee relationship is there. Quickly on the rights and obligations from a fiduciary perspective or a controller perspective, rights alone or jointly, very interesting. That means if two people are together processing joint bank loan, both of them will be held liable as a fiduciary. They decide the purpose or the means, why and how, right? And the data processor is nothing but the entity which processes the or gives this or processes the data on behalf of somebody else. And who is the somebody else? Fiduciary or the controller. For the data principal, that is people like you and I, grievance redressal, correction, erasure, right to nominate. This is a very interesting provision. First time this provision is there. Nowhere in the globe this law is there. Data subject can nominate somebody else to exercise that rights. Generally our understanding of nominee is after death and other things. Here, even during the lifetime of the person, he can nominate this person to exercise all the rights for various reasons. Right? But normally this use case will come into picture in the case of death and incapacity. Right to information, he or she has access to get more information about the person. It is always a right of the data principal, but the principal also has certain duties. Means you and I also have certain duties when we are dealing with information. First, I should not impersonate others. In the digital world, I can share my information and say this is somebody else's information. Or I can share somebody else's information and say this is me. How will you believe it? So, the principal has a right not to, or duty not to impersonate. Not to suppress any material information. Not to register a false or frivolous complaint. Furnish only information which is very authentic. People have been blackmailing under GDPR. Some fellow wanted pocket money or found some money. He saw some company which violated the data privacy. He said either you give me money not to complain or you'll go to the Data Protection Board of UK, Europe and etc. and make the complaint. So that was a misuse. Again, that is something which they have said. And on the data principle also there is a penalty. On the data principle also there is a penalty. But unfortunately that penalty is only capped at 10,000 rupees. Whereas in organization, this goes way beyond. Fiduciary, this if you ask me is your checklist for audit. Engage with the data processor to process personal data on its behalf through a valid contract only. No contract, no processor. Obtain verifiable parent consent, and this is a very very difficult thing for Byju's or coding platform to do. I'm just giving an example of Byju's and this thing because we all know. Why? What is the practical difficulty? Question number 1. I have to first verify he or she is a child. If he or she says that I am a child, I have to get parental consent. How do I get to know that obtaining parental consent is first question. Second question is, how do I make sure that that fellow is this person's parent only? You have seen in all these movies, right? In order to convince the bride or the bridegroom, some dummy parents come into picture. That can happen. So how do I prove it? Sir, do I have to ask them to upload birth certificate? Unfortunately, maybe yes, sir. I may have to upload a birth certificate or a passport to prove that he or she is a parent. But interesting question, how will you prove that that parent's email ID is this only? Give a consent. So, this is an obligation of the fiduciary to employ or deploy a verifiable parental consent mechanism. A little dangerous, but that is something which we have to do.
But practically it is highly impossible.
Very difficult, sir. Very difficult. Forget about India, sir. Even in the GDPR, people are finding
Then you have to have a medical practitioner to test a DNA and
no, we will not go to that level. No. We may probably have to, have a social security number linkage, an Aadhaar based linkage, maybe on those. Like because in case of a minor's Aadhaar, parents' mobile number and other things will be there. So through that we will have to do. That's how they have done it in GDPR as well. Passport is one of the means through which I can correlate social security. Report personal data breaches, provide clear, concise, comprehensible notice, delete and cause the processor to delete the data, abstain from processing personal data, or implementing technical and organizational measures. We do not know what these measures are, they are going to come up with it. This could be security, encryption, all the fancy names you speak of, it will come. I think I already spoke of significant data fiduciaries, so skipping that. These are specified categories of fiduciaries whom the government or the central government will notify based on their nature of processing. Their obligations are very simple. Mandatory DPO has to be there. In GDPR, every company should have DPO. In Indian DPDP, only significant data fiduciary should have a DPO. Right? Second, appoint an independent data auditor. Again, the word independent is important. You are giving consultancy services, you cannot do independent data, right? And periodically you need to do this DPIA. That's another interesting thing. DPIA talks about how privacy information you are capturing, protecting, assessment of that. There are a lot of templates online, but in general it should comprise of this process of processing, the purpose, the means, disclosure, all of those. A few special points I think on breaches I told. Anything that compromises the confidentiality, integrity and unauthorized process. I think we made a mention of that. As far as personal data breach is concerned, a data fiduciary is to protect the personal data, and in the event of breach, it has to intimate to two people. One is the board, second is the principal. But what is the definition of breach and when do I have to intimate is not clearly mentioned. So even one email ID got accidentally leaked, should I have to intimate? As of now, yes, but this is going to be notified in due course. I think we spoke about the board. Retention of personal data, interesting. How long can I retain the personal data? It is based upon consent and agreement. So if you feel that you as a regulator you need to have it for 8 years, then mention in the agreement so that you don't have any confusion. Or if you have received a withdrawal request, then immediately you have to delete unless there is a larger obligation, right? Whichever is earlier based on the law enforcement. Cross-border transfer, I think I already shared this. Unless it is prohibited, absolutely fine to what? Go ahead and keep your personal data in any other countries other than prohibited countries. This is a new role, just like how you have this KYC intermediaries. If you do KYC with this one person, that KYC details can be shared with all other players. This happens in the stock market, not in the banking market. Similarly, consent manager is going to come into picture. The consent, I have given my consent to this consent manager. Through the consent manager, overall consent is managed. So this is an interesting new line of service which might come. But again, he might become accountable to the data principal. Who is the data principal? You and I. He has to be accountable to us, right? So there are companies who are actually coming up. OneTrust is a very popular company in I think Australia or Europe. They are based off interesting provisions. In case of disability and children, the provision is very simple. The legal guardian or the parent shall be responsible for it. As far as penalties are concerned, in some cases it goes as high as 250 crores, right? 200, 250, 150 crores, whatever different scenarios they have given, right? Cross-referring to sections and other things. But summary is, the penalties is fairly high compared to any other legislation in India. And the intention is also very clear. Some insights, maybe my second last section or penultimate section. On employers, what could be the implication? I think I've already clarified this. Employer is permitted to process the personal data. No problem. However, he shall use it only from a employment obligation protection mechanism. If I am going beyond that, I am sorry, you may have to take a consent. Right? So that is something which you will have to be a little careful about. And how do I do it? The best way is in the contractual agreement itself, enter it. And if you feel, sir, I am already having so many employees, how do I do that? I am having so many articles, no problem. Online one template you create, ask the person to click accept with their email ID or Gmail ID, whatever is there. On companies which are new age companies, all these artificial intelligence, all these fancy stuff, right? As long as they are processing anonymized data, no problem. What is anonymized data? I am processing data, but I cannot identify whose data that is. Now, many of these startups who are into data science, they are doing it in healthcare. They go to one of these laboratories, they take all the X-ray reports of the laboratories, and this is happening. X-ray, this thing, laboratory sells information to these startups. All the X-ray related, only thing what they do is they don't tell whose data is what. They will say Mr. XYZ or Mr. All they just give some number and this is the diagnosis. For them to do research, which is still okay because your personal data is not getting revealed, right? So in those cases, if it is anonymized, no problem. But in all other situations, again you have to make sure that carefully you have worded it, because data includes even automated data. This again from a global practice perspective may not be relevant here because we are not GDPR practitioners, but in case you have done companies who have done the same, just give you a few insights. The DPDP is only on digital, whereas GDPR does not apply on it's not restricted to digital. Only even in paper form you are collecting information, GDPR will be applicable, right? Penalties exceed 20 million or 4%. Here it is about 250 crore. Minor age definition varies. Here it's very clear, it's 18 years only. In fact, in certain regions in Europe, minor definition is only up to 14 years. It depends on the region, the way in which kids are brought up and other things, 13 or 14 years. Breach has to be reported within 72 hours in GDPR. Here there is no specific time frame. Even after 6 months you report it, but probably will defeat the purpose, so they might come up with some practical guidelines. Next is transferring data, cross-border data. GDPR defines. DPDP does not speak about it. You need to have a DPO mandatory only in SDF. What is SDF? Significant Data Fiduciary. Then again, only an SDF has to do a DPIA, whereas in GDPR, any person who are dealing with high-risk processing activities is what the wordings they use. So coming to the last part, what is the way forward for organizations? You, me, our own offices, our clients, what do we do, right? First, I think the first step should be do a data audit. And when I call this as data audit, as the image indicates, it's like a discovery exercise. Because first you need to understand how you are obtaining personal data and where it is stored and recorded. Knowing the problem is the first step of the problem. Not knowing the problem is a bigger problem. To give an example, sir, all my clients send data only on emails, sir, no problem. 100% I don't agree. There will be some clients who send data on WhatsApp. Some clients, so many clients. First practice in your office, stop receiving any data on WhatsApp. With a clear indication that boss, if you share in WhatsApp, we are not held responsible. Even extreme case you have to do only on WhatsApp for whatever reason, then you have an office mobile number which has WhatsApp. And that you can connect through a desktop view or other things. So the problem with WhatsApp is you will not be able to track consent. Email at least you can search it. WhatsApp, how will you search? Right? So this is where the first exercise of conducting a data audit comes into picture. And when you are conducting data audit, first focus on where do we have personal data? What is the personal data you have? It varies from organization to organization. An automobile dealer may have a different type of personal data compared to a steel manufacturer, compared to a hotel, compared to a restaurant. Right? So first is nature of industry, what is the personal data they have, first to spend some time on that. And this is a discovery exercise. The moment you have that, in fact I would go one step ahead, not only should you identify where this data is, also identify how it is collected, how it is coming into your system. If these two principles are clear, the next step becomes easier. Review and policies, see how the data governance structure is in place. Obtain consent, right? Enhance data security measures because they talk about technical and organizational measures. Develop a breach response plan. For that, first people should be made aware what is a breach and how do you respond to it. Training is the most important thing. Vendor management. Why? Processor. Right? Data subject rights. Sometimes obviously you'll have to take legal views and opinions. Right? So these are all few action points which from our end we'll have to take it. But if you ask me on a practical note, the first point is the maximum time consuming. For doing a awareness, readiness, gap issue, whatever you can call it. Right? Every organization will have some other. I think focus on that particular element, I think you'll be able to solve it. So in short, if I have to give you a summary of the DPDP, first obviously applies only to digital personal data. Cross-border transfers are permitted unless prohibited. There's an option called as, there's a concept called as a notice and a consent. Notice is given by data fiduciary, consent is given by principal. Remember I told you that marriage. Rights and duties are obviously given. You have a data protection board. There is obviously a penalties and breaches. You have rights and duties of principals. I think I just repeated that, sorry for that. Processing for certain legitimate reasons and consent based processing. And then there are the concepts of voluntary sharing data and other things. Right? So I think if you ask me, that's basically the summary of this entire thing. So if I have to give you a nutshell, of course some just opinion or theoretical, yeah. If you ask me, this is a new era. We are already seeing the traditional avenues of practice, how it is getting impacted. Right? I think it makes sense that we start slowly into a consulting domain with these sort of skill sets and understanding. It could probably start with a very simple exercise of our own clients. For all it could be free of cost because we are also learning it. But eventually, as we do and uncover and unravel, this will become a specialist opportunity. And in a country like India, significant data fiduciaries are going to be huge in number. Right? And it's only a question of time that we are able to pick up pace and start doing more work on this. Right? Thank you so much for this wonderful opportunity. Happy to take any questions if you have. Otherwise, we are a firm based out of Bangalore, just like most of you. We have our office in the US as well. We recently set up, seeing the global opportunities. We have a CPA from there. The whole intention is we started, at least I started moving into the technology domain a few years back, and I do full-fledged technology-based consulting. And I'm seeing a lot of interesting turn of events, a lot of opportunities which has come up. And you will have noticed that, wherever I go, I speak only on technology, right? I write and author a lot on technology because I'm very passionate about it. And of course, I love to share my views and thoughts with all of us. Thank you so much.
I have a question.
Yes, sir, please.
Members have signed the attendance by the account and down. We collected the data online. When signing, when other few numbers are seen, is it a data breach?
Interesting question. is a data breach. Because they have given the membership number for what purpose? For the CA Institute to report CPE. Not for other chartered accountants to see another chartered accountant's number. So maybe what we should do, right, as Sir rightly pointed out, maybe you should, for the purpose of that limited printing, you may want to mask or do something with that. I will have to figure that out. Because you will have to correlate that with this, right? This is where principles of anonymization, pseudonymization come into picture. How to relate the first person and second person details.
Ballot boxes.
So I think we should, while registering CP also we should get consent.
Yeah, consent becomes mandatory, unfortunately. Wherever you go, put to consent, sir.
If you are utilizing clouds now, everybody, biggest organization, now the cloud provider is not processing data. He's just giving you the facility, and all the data is being uploaded in the cloud. So, and the additional question is, how does the cloud, as I understand, they have server all over the world, right? And you do not know where it is being processed. Wherever the space is empty, wherever the bandwidth is there, the thing get processed. So how the data localization work in those cases?
Okay. First question, processing definition, please look into it. Even if I am storing the data on a cloud or a Gmail, it is considered as processing. Right? So for a cloud service provider, DPDP will always be applicable. It is just that he may not be held directly liable. Why? Because he has not entered into an agreement with the end customer. For example, I am storing my customer or my client's data on Google Drive or OneDrive. Hypothetically, there was an error or mistake from my end, as a result the data got leaked. I will be held liable, not the cloud service provider. If the cloud service provider itself had a breach, he is obviously held liable. First. Second, the principle of data localization, how it is going to come into picture, this is where your terms and conditions becomes very important. The way most of these players work is, if you are having @Gmail, @Outlook, @Hotmail, by default, it goes to the US servers where the cost of processing is cheap. For a free consumer, you cannot decide too many things. If you want these sort of data localization and servers within India, etc., you need to be a paid subscriber and you need to go ahead with a domain name. In case of email, I can just give it, right? You need to have a domain name, and while subscribing or purchasing, you have to insist that the server has to be in India. That is possible. Especially when you are having S3 bucket or Google Drive or Google Workspace storage. In simple language, a server. Sir, what is cloud, sir? In a very, very simple language, let us say our own chapter has one 10 terabyte hard disk and tells all our chapter members, sir, we have got 10 terabyte hard disk. I will give you half a GB free for all of you. Or I will give you half a GB on a subscription basis, 100 rupees you pay per month. And all of us are accessing our chapter server, and only I can access it. Nobody else can access it. This is a cloud. Cloud in a layman's language is somebody else's computer which I can access it over an internet for a purpose. What is that purpose? File processing, information processing, update, software, whatever you can call it. For all I am just storing photographs. Right? So whether this fellow will be treated as cloud, the answer is yes. Now how do I know which location it is? Ideally, every cloud service provider has to disclose it. Unfortunately, the law is not very clear as to what are his obligations. Like for example, the consent of notice is there. Today, this as a part of the notice, that the cloud service provider has to disclose where the data is going to be stored. It's a mandatory requirement under the DPD, because that notice provisions, right, it's going to come. Until such a time, sir, I am kept in blind spot, we don't have an answer for it. So for now, we will have a challenge. But if you have a paid account, you can insist for it. Especially this banking and BFSA community, they are making sure that the data on the cloud is hosted only within India. So there is means and mechanism through which you can verify and get it. But I am an individual customer, I am not having visibility, I agree with you. Even me or you, for example, all our Gmails are not hosted in India. It is hosted in US. Touch wood tomorrow, between Canada and India, some sort of, I will not use the word as civil war or whatever, I just use the word, some sort of a tension is there. Somebody wants to, cut off that connection, we will not have access to it. Do we have a Make in India email ID? I do not know. I think Zoho is having that. Zoho is a product suite of India. And there are some players who can do it.
A telephone directory is a data breach. Yeah?
Sir,
Telephone directory is a data breach. Yeah?
telephone directory first and foremost is physical, going with the old mechanism.
Okay.
Now going to the digital mechanism. In case of a digital mechanism, let's say at Just Dial, you have registered your number and contact details with Just Dial. What is your intention?
What?
Your intention is to get calls and customers or get inquiries. So you are deliberately providing your information and Just Dial is taking a consent from you that their information is going to be publicly available. As a matter of fact, I will put it other way around. Monster.com, you are uploading your resume. You cannot call it as a data breach. If Monster.com has intimated to you that you are uploading your CV, I am going to make your details publicly available or I am going to make it available to recruiters. You can't do it.
No, this Truecaller.
Truecaller is a big story, sir.
They take up your address book.
Truecaller to some extent is a violation of privacy.
Violation.
Because what happens is, unfortunately, the Truecaller logic is, let's say I am calling sir, and sir does not have my number. But let us say you have my number, and both of you are connected. So what Truecaller initially was doing was, it will go and search that in his contacts, which is you, have you saved my number? A network basically. Then it will display to him this person is so and so. So if you ask me, is it a violation of privacy? To an extent it is yes. But who will file the complaint? Are you going to file the complaint? He will file the complaint? No. Because he is using it because he gets to know that I am calling. And I don't even know he gets to know that this thing, right? In fact, in some case, it has happened with many of us. We would have given our number for some client for OTP registration or something. So when you call up, some other client's name is also appearing in your call. So that's a little tricky thing. Whether it is going to be a violation of privacy, I personally feel it's a violation of privacy.
No, the social networks also, they take up all the data and they link it, and again they
we as a product, we have signed up for one. If you go to the terms and services, if you read that, you will never use social media. But again, we have got used to social media.
No, earlier this DP reading was not there.
Now they will go under consent clause.
No, now since it has come now, and there is.
They will update the privacy policy. That's all. They will update the privacy policy and they will say, for you only we are doing this. For you only we are doing this. Why? We have to give you relevant advertisement. We have to give you relevant content, so that when you swipe right next time, correct information and video comes. It's a game. We are all trapped into it. No other option. That's why I keep on saying, if you want to be very, very secure, don't have any online accounts. As the best machine today is a machine which is shut down. There is no possibility for any sort of leakage and other things, right? So anyways. Any other questions? Great. Thank you so much. Happy to have spent some time with you. Happy to share. Happy to see faces. Because pandemic, and at least a year after that we are still using webinars and other things. I don't even know who on the other end listening, or at least happy to see so many faces and attentive and cross questioning and everything. Thank you so much.
Thank you for the wonderful session, sir. Now that we know what is data processing, consent, security, privacy and protections, let's be ready to implement the same. It's my privilege to present a memento to the speaker as a token of gratitude. On behalf of Bangalore branch of CA Nrasimhan Elangovan, managing committee member, thank the speaker for the session, the wonderful participants for the participation. I hope members are aware that registration for virtual CPE session for 55th regional conference of SCM is available, which is scheduled for tomorrow and day after. Our next statistical meeting is on next Wednesday, 18th October 2023, on the topic NCLT latest updates. Thank you for